Crest, Nicholson and Akaria investments were involved in a housing project in London. Akaria had the land and Crest Nicholson were the developers. There were quite extensive agreements about how the project's profits would be shared. One provision said that if any units had not been sold 2 years after the development was finalised, Akaria would make payments to Crest Nicholson based on the market rent of those units. Before the 2-year deadline was reached, however, the parties seemed to have had some discussions about how precisely to calculate the amounts to be paid to Crest Nicholson. After the meeting, a representative from Akaria sent an email to Crest Nicholson which said in part, "Following on from our meeting on Friday the 8th of June 2007, I think that it is important to set down the approach that we have agreed." And then he gave the details. The response from Crest Nicholson said, "The proposals set out in your letter are all acceptable." By the time the 2-year threshold was reached, both of these people who seemed to have made an agreement had moved on. All anyone had was the emails. The question for the court was whether there had been an agreement in the nature of a contract established by the emails. Ultimately, and with some hesitation, the court said no, there was no agreement. Sir John Chadwick, the judge who wrote the leading judgment, said that the original email was not an offer. It did not set out a proposal capable of acceptance. Instead, the email sought confirmation that what has gone before reflects or records matters which have already been agreed. They do not invite agreement de novo to matters which have not already been agreed. In other words, the email couldn't be an offer in circumstances where, according to the email, the parties had actually already reached agreement. And the response to that email didn't say, for instance, "I agree that your email accurately records our agreement." It refers to proposals. So there was no offer and no acceptance, even in circumstances where the parties did seem to have reached an agreement. From this case, we learn that in order to be an offer, a statement must set out terms which are capable of acceptance and which will become binding upon such acceptance. A statement referring to prior agreements is therefore not an offer.